We're going to begin. We'll call to order the Wednesday, March 22nd, 2017 Board of Commissioners meeting, special meeting. Please rise for the pledge.
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Roll call, please, Bonnie.
Wheelock?
Yes, ma'am.
Mayor?
Here.
Lathrop?
Here.
Johnson?
Here.
Gorfulet?
Here.
Klaus?
Here.
Crawford?
Here. Now we have our first chance for first public comment. So Bonnie, will you read the rules, please?
Any person shall be permitted to address a meeting of the Board of Commissioners which is required to be open to the public under the provision of the Michigan Open Meetings Act as amended. Public comment shall be carried out in accordance with the following board rules and procedures. Any person wishing to address the board shall state his or her name and address. No person shall be allowed to speak more than once on the same matter, excluding time needed to answer commissioners' questions. The chairperson shall control the amount of time each person shall be allowed to speak, which shall not exceed 3 minutes. Chairperson may, at his or her discretion, extend the amount of time any person is allowed to speak.
Okay, so does anybody want to have first public comment? Mr. Largent.
Steve Largent, Grand Traverse County Drain Commissioner, address 5445 Sharman Road, Traverse City. I was glad to see the issue that is on number A on the open session being the law regarding the co-employer relationship between county commissioners and elected officials. And I read with great interest about the county board is legally required to provide the funds necessary to permit elected county officers to carry out their statutorily mandated duties at a serviceable level. And as I've gotten into this job, obviously the previous commission reduced the salary for the previous drain commissioner to a level that was, I don't think, based on anything other than what the commissioners were making at that time versus the needs of the job. Because since I've gotten in here, I've seen just a tremendous amount of work that needs to be done. And I plan to come to this board at the April 5th meeting with a couple of those items. One is going to be to talk about the records, and there's some electronic and paper files that currently can't be located, and also some of the potential liabilities that might be out there for the county. Secondly, we're going to be also talking about the Duck Lake drain. That comes before judge on May 8th to legally set that lake level. And so there's a lot of work that needs to be done. And otherwise, there's the Cass Road Drainage District, which will not happen this year. It's going to have to be bumped until 2018. I got a call just in my office this evening, just before coming in here, from a gentleman who owns the cold storage, wondering what the plans are, because they, of course, were affected by the flooding that went on, and also any plans that we have for upgrades there. So it's really inconvenience for those folks. But then the county has a SAW grant that you folks backed with a resolution, and there's no record of activity on there, yet there's some work that's been done against it. There's the Silver Lake drain that needs maintenance and clearing. The Duck Lake drain, like I said, is coming up, and also the Silver Lake drain needs to be reassessed. They asked for that themselves, so that because that account is real low, but there's a lot of work that still needs to be done. Cedar Run drain, and it goes on. I received a call from, and I'll end with this, but I received a call from a gentleman who lives on Long Lake just yesterday, and he said that the water's rising in his yard, and he says he's lived there, he's an elderly gentleman,
You can
And
continue.
I'll leave it at that, so.
If you need to finish your point. you can.
But yeah, what he said is that, there used to be 3 culverts that drained this large swamp, and 2 of those culverts are now been developed over, and there's only 1 culvert that's now allowing drainage into Long Lake, and he says now a new couple have purchased that property, and he says they put up a fence so he can't even see if any debris is building up against that culvert, which causes that wetland to rise and fill his holding tanks and costing him, money. So, and I don't have the time to go out there and check it out at this point. So we really do need to serve the citizens of this county better. Thank you.
Thank you. Anybody else like to make public comment at this time? There'll be a second chance, but it'll be after our closed session, so. Anybody? No? Okay. All right. We will move on to open session part of our meeting this evening, and we have Mr. Peter Cole, who has a bit of a presentation for us on some legal matters.
Correct.
Okay?
Madam Chair, thank you. I have a bio in there. You can read it if you want, throw it away too, whatever you want. But our firm has been practicing public sector labor law for 35 years or more. There's 9 lawyers in our office. That's all we do. We specialize in county and municipal law. We represent about 30 counties at any given time. So we do have that kind of expertise. What I was asked to do is keep it relatively short on some of the co-employer and some of the legal aspects of the co-employer relationship. And I'm here to answer any questions which you may have. So I'm just going to highlight those important areas on this. And you all have a copy. You should have received a copy of my outline. A lot of this was simply, a couple of these were articles that I prepared for the Michigan Association of Counties, were in their newsletters. It's still valid law, so that's why you see some of this. The difference, the elected officials, the 6-wide county elected officials are co-employers with the County Board of Commissioners. The elected officials have the authority to hire, fire, discipline, and manage their departments. The counties, on the other hand, the County Board of Commissioners has the exclusive authority to determine economic aspects of the elected official's office. And there's only, as the Drain Commissioner noted, there's only one limitation on the Board of Commissioners when it's funding the elected officials, the 6-wide county elected officials. You must fund them so they can perform their mandated functions to a serviceable level. So the first thing you look at, is it a mandated function? There's a lot of functions that are performed by, can you hear me okay? Mm-hmm. There are a lot of functions that are performed in some of your offices that are not mandated. So if there's a budget crunch, the first thing to determine is it a mandated function? If it is, you need to fund it. Then the second piece of this is you must fund them so they can perform their mandated functions to a serviceable level. The court in 1979 said a serviceable level is the bare minimum by which to get by on. It's urgent, it's extreme, it's critical, it's vital. So it's a very high standard. And the court went on to say you have to fund them only so they can perform their functions in a barely adequate manner. Now, over the years, since 1979, I've been involved in several disputes regarding this, representing commissioners, and the commissioners have never been on a losing end of that because the standard is so high for an elected official to receive more funds from a county. So, but keep in mind, you still need to work together. That's crucial between the elected officials and the Board of Commissioners. So when you look on page 3 of the outline, and once again, I'm rushing through this a little bit, but I'll take questions. Economic issues. These are your issues. Number of employees in each department. Pay ranges. Paid time off. Paid vacation days, holidays, sick days, etc. So these are your exclusive rights under the law, and that's on page 3 of the outline. So you determine all economic issues. Your only limitation, once again, is you have to fund the elected officials so they can perform their mandated functions, determine what's mandated, to a serviceable level. Serviceable level is a bare minimum to get by on. Then the non-economic issues are solely and exclusively determined by the elected officials. Who to hire, who to fire, management issues. Now, this is all subject to collective bargaining under the Public Employment Relations Act, PARA. So under PARA, what's happened is this county, and as all counties, have negotiated contracts over the years, and the elected officials have given up some of their rights under their collective bargaining contracts. Some of the things that I observed under your contracts could be extremely detrimental to some of the elected officials, and I'll talk about that later. For an example, bumping. If I'm in the clerk's office, for an example, and I have an employee that's going to be laid off, if that person has more seniority than someone in the treasurer's office, can that person bump in the treasurer's office? The treasurer's going to say, I don't want to let my person go. The person's been there for 5 years. This other person doesn't know anything about the treasurer's office. So you have some cleaning up to do in your collective bargaining contracts, in my opinion, in order to have more efficiency in the county. And what happened before we got started is what I always recommend. You send a letter, Mr. Menzel will send a letter to all the elected officials, and he asks them, are there any non-economic issues which you would like addressed in the upcoming negotiations? So they were all afforded the opportunity to provide to the employer's bargaining team whatever concerns they may have had relative to non-economic issues. All right, so basically what you have is a situation where elected officials hire, fire, discipline, manage, assignment. Commissioners determine all the economic aspects of it. You need to have that cooperation. Like I said, I always recommend that you ask the elected officials if they want any changes. This was done in this case. So that's basically in 5 minutes. Did I do okay, Commissioner? In 5 minutes, that's the summary of the relationship between the Board of Commissioners and the elected officials, co-employer. Any questions? Yes, sir.
I want to understand, you said that when these things, minimum funding the elected official at a minimum level so they get their job done, that usually ends up being supported by the courts? Or
Yes.
does it usually end up being the other way?
No, I've never lost a case like that. And they're very rare. I mean, I've been doing this a long time, and I think I've only had 4 of these over all these years where there's been some litigation, and it's very rare for that to happen. You don't want that to happen. You want to avoid that. You don't want to have a litigation between the county board and elected officials. Yeah. And the few times when there was litigation was because the elected officials, for whatever reason, decided they wanted to proceed with it. And none of them, they were not successful. None of them were successful.
Okay.
All right, the next area I'm going to talk about briefly, keeping on my timeline here, is the next outline, legal update on collective bargaining. Legal update on collective bargaining. This is probably, in my opinion, of course I'm a biased labor lawyer, is the most important piece of legislation to help public employers. And I'm only talking about counties, cities, villages, and townships, not other types of public institutions. This legislation, to me, was the most important legislation passed since I've been practicing law. And I started practicing law in 1888, so it's been a long time. So what this statute did was, and this was in 2011, before this statute, what happened was, once a collective bargaining contract expired, the County Board of Commissioners was required to continue all the terms and conditions of the contract. So for an example, if an employee was scheduled for a step increase after the contract ended, you had to give the step increase. If the insurance costs went up 35%, the employer, Board of Commissioners, had to absorb that. If the employee was scheduled for a vacation increase, a bump, let's say, based upon years of seniority, after 5 years, maybe they got 3 more days, you had to provide it. So there wasn't any incentive for the unions when you had when you had bargaining where you wanted to take back certain items because of the economic circumstances. There wasn't any incentive for the unions to settle. And I would be in the same situation. After this passed in 2011, the shoe was on the other foot. Now, the law says once a collective bargaining contract expires, the Board of Commissioners cannot legally give a step increase to an employee that would otherwise receive it. The law says you cannot legally give an increase in vacation time once the contract expires. This law also says that there's any increase in fringe benefit costs, such as health insurance, life insurance, dental insurance, the County Board of Commissioners is legally required to pass that cost on to the employees. You have no choice under the law. It also says that you cannot legally agree to retroactively give a step increase to an employee that missed their date. So let me give you an example. Employee was scheduled for a step increase January 1st, 2017. The contract doesn't settle until May 1st. You cannot legally go back and say, okay, January 1st will pay you the retro for the time you lost. You can't legally do that. You start it from that date forward. Now, there's one case, and my outline talks about all this, there's one case that says that does not apply to retirement costs. So if there's any increase in retirement costs, you're the stuckee. The Board of Commissioners has to absorb any additional cost in the retirement. Yes?
So obviously, the motivation of the legislation is to encourage fair contract negotiations and encourage parties to reach new agreements before the existing contract expires, correct?
Yes.
Okay. So is there a clause in the law that allows for bargaining in bad faith?
Oh, yes.
Okay.
Absolutely.
So just to be clear, although it says it's not legal, if there's bad faith or malfeasance on the part of either party, that would have an impact.
Absolutely. So for an example, if the employer was dragging its feet and saying, I don't have any time to meet with you for the next 6 months, 8 months, that would, an unfair labor practice charge would be filed, and you violated your duty to bargain in good faith. So there's no question, there's remedies. Now, this law does not apply to police officers and firefighters starting in 2014. And I give credit to the labor unions that represent police officers and firefighters. They lobbied and did a wonderful job for their membership and excluded them from PA 54. So what I'm talking about here does not apply to your sheriff's department deputies. It does apply to your corrections officers, because the exclusion under this act only applies to law enforcement, those persons that are subject to 312. And corrections officers are not eligible to go to this, what's called binding arbitration under 312. So the moral of the story is this applies to deputies, law enforcement. They're excluded, but corrections officers are under PA 54. Okay? I'm moving quickly. Okay. Kick me a little bit too, Commissioner, if I'm going too slow.
No, you're
All right.
fine.
All right. I'm not going to talk about Public Act 312 because you don't have, I'm going to skip over that, that's in my outline, because you don't have anybody right now where you're going to 312. Those contracts don't expire until the end of this year. At some point, you should be updated on 312, but it's not necessary for right now. And I think that's about it. Now, what I've also done here is I have more extensive information here, none of which is necessary for our purposes tonight, but, take a look at it at your leisure. One other statute, or just one other process, the way what it works, and this is what you suggested, Commissioner, the employer and the unions are required to commence negotiations within a reasonable period of time prior to the expiration of a collective bargaining contract. And all contracts that I get involved with always have a provision in there, 90 days, 120 days, 60 days. Prior to the expiration, either party can request negotiations. And that's what we do. What I normally do and what's happened here in this county is we sent letters out to all the unions ahead of time, way in advance, saying we're about to start negotiations. Would you please send us your proposals ahead of time? If we get your proposals, I'll review them with the client and we'll send you ours. So you save a couple of steps there. You usually save a couple of meetings. They don't always agree to do that. Some unions say yes, some unions say no. But at some point, you're sitting across the bargaining table. You're negotiating in good faith. You can't get a deal. You can't get an agreement. So after negotiating X number of times, you can go to mediation. And mediation, and I apologize for those that you know about this, mediation is, you have a state employee who's a mediator. He or she comes and tries to assist the parties in settling the contract. And they're usually pretty successful. I've had really good luck with mediators over the years, and you've had some outstanding mediators. And unfortunately, the best mediator just retired in January. He was a terrific mediator. He used to work for a union. I used to negotiate against him. But he was terrific mediator. So if you can't get a deal in mediation, you're going back and forth. Usually you have a couple sessions. The employer can implement its last best offer or parts of it once you reach impasse. So for an example, I had 5 negotiation sessions, 3 mediation sessions, and the union won't budge, the employer budges a little bit, the union won't budge at all. If we're at impasse, you can declare that, and then you can implement part of your last best offer. Now, the idiosyncrasy here is that, however, if a union files a petition for fact-finding, then what occurs is you are locked into the status quo until you complete the process of fact-finding. So what does that mean? This happened here. We had 5 negotiations with Teamsters units, and we were in mediation, and the day of mediation, he gives me the petition for fact-finding, and I get along really well with the Teamsters business agent. I've known him for years. He's a fine man. I really sincerely mean that. I know some people don't feel that way, but I certainly do. I've never had any issues with him at all. So he hands us these petitions for fact-finding. Now we can't implement our last best offer. So now we have to go to fact-finding. And what happens is the state of Michigan gives you a list of people, and you select the fact-finder. You can strike some names. Then the fact-finder has a hearing date, and then you present your case. Why the fact-finder should rule in your favor. Each side presents their case, their evidence, the facts, the circumstances. Then the fact-finder then renders a recommendation, not binding, a recommendation. So you get the recommendation, the parties that like it, they got a deal. The parties don't like it, then you have a duty to negotiate for another 60 days, and after that 60 days, then the employer can implement its last best offer. I recently had a situation in a county, it was a road commission, where the fact finder recommended that the employees pay a total of 13% towards their retirement costs, because the cost was 37% of every dollar paid to an employee. The employer had to pay 37% towards retirement costs. So the fact finder said, I recommend the 13%. The union said, no, we don't agree to that. So we sat down, 60 days later, then we implemented our last best offer. After we implemented our last best offer, the union files an unfair labor practice charge claiming we didn't reach impasse. So you litigate that, and eventually we won. It was a long, drawn-out process. I don't like fact-finding, but I'm bringing this up to you because we have 5 units right now that are in fact-finding, which I'll talk about in closed session, that filed for it. But ultimately, you can implement your last best offer. Okay, so that's basically the aspect of negotiations. Negotiations in good faith across the table, mediation, hope you get a deal, and 98% of the time, I get a deal in mediation. It's rare. I've only been to fact-finding, and I didn't add it up, maybe 5 times in 30-plus years. It's just a waste of time, generally speaking. I had one case where we went to fact-finding, and the employer didn't agree with the fact finder's recommendation. There's not much you can do about it. In other cases, the employer did agree. Okay, next area, right to work. I'm not going to spend much time on that, but you have some cases. You have some cases right now on some contracts that actually are in violation of the right to work statute. For example, we just recently settled the ASME contract, and I commend them, and I thank them for working with the employer. They were terrific. They really were. And it was hard for them to do this, but they recognized the need, and we have a signed contract, and you receive copies of that, I'm sure. But under the right to work statute, you cannot require an employee to be a member of the union or pay a representation fee or to contribute to charity as a condition of employment. So you cannot say to an employee, if you don't pay union dues or a representation fee or contribute a like amount to a charity, we're going to fire you. Before the statute, you could. The parties could agree to do that before 2012. The parties could sit down and agree to do that, and most public employers did that. But now we can't do that. Now it's up to the employee to make a determination whether or not he or she wants to pay union dues. And if they don't pay union dues, we can't fire them. And I'm not talking about whether it's fair or unfair, so on and so forth. That's just the law. And some of your contracts need to be changed in that regard. Okay, next area.
Is that on one of these pages, what you just said?
Yes, sir. I have important legal update, Michigan's new public sector right to know. That should be a separate item. It was another article that we did.
Okay. I was just looking for a page number.
I don't know what page that is. I just don't know. I think she numbered it
23.
as 20.
23?
I'm not sure which number that is, but all of this, what I'm talking about now, the co-employer legal update, and the right to work. That's all articles that we've done or summaries that we've sent out to our clients prior. The next area of the law, and I see we have some court people here, is the courts are unique, okay? And they are not subject to a co-employer relationship with the Board of Commissioners. They're a separate legal employer. Now, there was, I think in 1995, there was some legislation that they said that the court employees would become employees of the county. And I looked at that and said, yeah, terrific. That's not going to last long. And the Supreme Court ruled that was unconstitutional because of the separation of powers. So the court is a separate employer. But what happened was the Supreme Court, I actually negotiated this, this Administrative Order 98-5. It was at first 98-7, then 98-5. I negotiated this with the Supreme Court staff way back yonder, and they came up with this administrative order. And this is very, very important. It helps, and for the most part, there's a good relationship between the courts and the county in most of the places where I do work. And it's a rare occasion when you have a problem. But when you do have a problem, it's trouble. But it's rare. But in this, under the Administrative Order 98-5, which you have a copy of, it says if a local funding unit, which is the County Board of Commissioners, requests a line item budget, which you should always do of the court, then the court cannot, without the acquiescence of the funding unit of the County Board of Commissioners, create new personnel positions, supplement existing wages or benefits, except to the extent that you, the funding unit, do that for your employees. So let's say, for an example, you give a 1% increase to your employees. The court wants a 2% increase for its employees. The court cannot legally do that. They can give a 1%, but not a 2%. Then also the court cannot reclassify an employee as well to a higher without the acquiescence of the funding unit. And my experience has been there's never been a problem. And well, I shouldn't say never. There's usually no problem, because what happens is the court comes in and says, here's why the person should be reclassified. They're doing higher paid work, and it usually occurs. Not always, but usually. So basically, I'm not going to get in more than that, but I'll also say is that under this administrative order, the Supreme Court has said to the lower courts, to the extent possible, the courts should have personnel policies consistent with those of the funding unit. To the extent possible, they have personnel policies consistent with the written personnel policy of the funding unit. Well, most of that's possible all the time. So my experience has been that most of the courts have cooperated, and they've had personnel policies consistent with the funding unit. And there's also, like, when you close, if the court wants to close due to weather conditions and that sort of thing, there's provision in there that the court can do so, but the employees must either take it unpaid or they can use their accrued vacation time. So there's that. The Supreme Court was good. The former Supreme Court Justice Conrad Mallett, he was the one that was instrumental in assisting counties in doing this way back yonder in 1997, 1998. Okay, I am finished with that part unless there's some questions.
I have a question.
Sir.
Okay. When you request the court to do a line item budget, that kicks in those rules that the administrative rules of the Supreme Court. Do you have to do that every year?
Yes.
Okay.
Every time you do a budget, you simply request of the court a line item budget. And I have not, well, we'll talk about that later, but I haven't detected too many problems in places, with county boards of commissioners. I've never had a problem with resolving any differences between the court and the county board of commissioners, except once. And oh boy, was that ugly. Had to go all the way to the Supreme Court, and we finally won on a 4-3 split decision.
So
it was awful.
Are we doing this every year? Are we asking that? Okay.
We have.
We don't have to, as a board, ask you to do it. You just do it automatically.
A letter comes from the board chair. Last time, we were directed by the chair to do that.
Okay. Cool.
Okay. I'm doing good so far, a half hour. I'm beating by 10 minutes what you told me. All right, the last thing, D, under open session, just a review of the dismissal of the 5 Teamsters unfair labor practice charges by the administrative law judge. And the reason why that's not in closed session is because to go into closed session for this, it has to have a detrimental effect to litigation. There's no detrimental effect. So that's why I'm bringing it up. Otherwise, I wouldn't bother with it. The law judge ruled against the Teamsters, dismissed their 5 unfair labor practice charges, and then the Teamsters withdrew 4 out of their 5 grievances. This deals with the 20% that the employees pay towards their retirement cost, towards their health insurance costs. That's what these deal with. The parties had until, I think it was March 9th, to file exceptions. In other words, if they disagreed with it, they could appeal it. They're called exceptions. And neither side filed exceptions. We certainly didn't. And now what happens is the next step and the last step is the Michigan Employment Relations Commission, which is a panel of 3 people appointed by the governor, then either accept the recommendation of the administrative law judge, modify it, or reverse it. So we haven't received that official stamp of approval yet because the Merck panel hasn't given it to us. But I fully anticipate we shouldn't have any issue relative to them upholding the decision of the law judge.
Now, that was Teamsters groups, right?
Yes, sir. The other units, which we'll talk about in closed session, are specific pending litigation right now, and they're going on right now. Any questions? If there are no questions, I would suggest...
Can we have, there's a question from the audience. Go ahead.
Carol, I think you're
You
going
have to come up to the podium.
I was just wondering if Mr. Cole could speak specifically to what the last best offer means.
Please, thank you.
Okay. The last best offer is a term of art that after you sit down and negotiate with the unions, go back and forth, and you're usually 99.9% of the time there's give and take. I've never had it, for me anyway, 100% of the time. So what happens is you're negotiating back and forth. You change your position, the union changes its position. You negotiate X number of times, then you go to mediation, and then you get stuck. Then you say, I'm not going to move anymore. That's it. I'm in cement. I'm not going to move my position 1 iota. The union says the same thing. So you're at impasse. That's called impasse. The legal term would be impasse. Then what happens is the employer says, I'm going to give, this is my last best offer, like take it or leave it. When you get your last best offer, that's when all this stuff kicks in about implementing your last best offer. But it's really a situation where you're not going to move anymore. Okay.
Thank you. Anybody else? Nope. Okay.
I believe I would suggest you go into closed session with this motion.
I have it. Yep.
Yes, ma'am.
Okay.
Before we go into closed session,
Yes,
I did
ma'am.
have something.
Okay.
I would ask that at the April 5th, which is the next, I think, public meeting that we're having, I would like to bring up the issue of the audit and whether or not we are going to be seeking bids for a new auditor.
Okay.
So that's something that I would like on the agenda for the 5th for a vote.
Okay. Thank you. I put it on the list. Anybody else have anything? I don't anticipate at this time any decisions being made once we come out of closed session, but you never know. But I don't anticipate that right now. Yes, Bonnie?
This is a study session. You can't.
We can't make
It's a special
decisions
board-
anyway,
it's a-
so there won't be any.
It was posted as a special Board of Commissioners meeting.
Oh,
Not this one. The one next week was.
No, this
There
one.
is
no,
one
this is
next week.
posted as a
This one-
special meeting.
This one's
So we
posted as a
could.
special meeting.
Actually, this is not a study session.
I'm
Yes.
sure, check the
Thank you,
agenda,
though.
doesn't it say special meeting of the
Yeah,
Board of
it says it right here on
But I
there.
don't anticipate it, but like I said, you never know. So, I would move that we go into closed session for the purpose of discussing with Labor Council, number 1, contract negotiations for various bargaining units, and number 2, various grievances and unfair labor practices charges filed by various unions regarding employee health insurance payment under PA 152. This motion is made pursuant to MCL 15.267 and MCL 15.268C and E. This motion shall require a 2/3 roll call vote of members elected and serving for MCL 15.268E litigation. The roll call vote and the purpose for calling the closed session shall be entered into the minutes of the meeting as prepared by the clerk.
Support.
We have motion and support. Bonnie, roll call, please.
Mayor?
Yes.
Lathrop?
Yes.
Johnson?
Yes.
Gorfulet?
Yes.
Klaus?
Yes.
Wheelock?
Yes, ma'am.
Crawford?
Yes.
Pursuant to that, let's go. Pursuant to that.
Ends of these meetings.
Madam Chairman, I would move to come out of closed session.
Support. Moved by Commissioner Wheelock, supported by Commissioner Gorfulet. Any discussion? No? All in favor?
Aye.
Any opposed? We move on from here to second public comment. Anybody? There's no public left, really.
Greg's here.
Okay, and we are adjourned.
Great. Nice job, you guys.
I was hoping to give a 20-minute commissioner notice.
And I'm not going to let you do it.